family law, there can be a question on restitution of conjugal rights. So here in India, in most in our Hindu laws or whichever law, marriage is considered a sacrament and a holy bond. So, however, if the marriage does not work, a situation may evolve in which one party does not feel like staying, leaving with the other. So, the restitution of conjugal rights, on the other hand, gives the spouse the right to summon the other spouse to live with them. So, the spouse with them again. While this right appears to be valid in the sense that it provides a solution to rescue the relationship and the family, so it does not appear to be legal in the sense that it requires one to stay with the other unwillingly. So, when we file a case in the court of law, for example, if two people are separated, we may file a petition of restitution of conjugal rights. So, this is consequently, this right has always been a contentious issue which doubts about the constitutional validity. So, that is Article 19 is violated over here, it seems. So, some of the other questions that need to be addressed are whether a man would be held liable for marital rape if he is merely claiming his conjugal right to have a physical relation with his spouse, and is it possible that this right infringes on a spouse's right to privacy by compelling him or her to live with the other spouse, so thereby shredding the right over the self body. So, there can be a question on whether it violates the articles in the constitutional law. Now, when we talk about Article 19, Section 9 of the Hindu Marriage Act 1955, which deals with the restitution of conjugal rights, reads this way: when either the husband or the wife has without reasonable excuse withdrawn from the society of the other, that is, withdrawn from the society of the other, the aggrieved party may apply by petition in the district court for restitution of conjugal rights, in the family court also. And yes, and the court, on being satisfied with the truth of the statement made in such a petition, and that there is no legal ground why the application should not be granted, may decree the restitution of conjugal rights. However, the burden lies on the person who has withdrawn to prove that there is reasonable excuse for their withdrawal. The essentials include: 1. They must not have been cohabiting, and there is no reasonable ground for the withdrawal of the spouse from the other. Number 2. Not performing the marital obligation. If both the conditions are fulfilled, then the aggrieved party may file for the restitution of conjugal rights. But the court may not grant the decree when it is proved that there exists a reasonable ground, or if it is proved that the petitioner has done any matrimonial misconduct which makes it difficult for the other to stay with the spouse who has applied for the restitution of conjugal rights. So, a very important point over here is both the conditions have to be satisfied, then only. Now, the question here will be whether it violates Article 19(1)(c). A spouse is compelled to reside with his or her spouse against his or her will of a decree of restitution of conjugal right is granted, if it is granted. Now, this is violation of Article 19 of the Indian Constitution. In Huram versus Misri, by the wife left her husband because her father-in-law had an evil eye on her and the husband treated her terribly. Even after that, the spouse was awarded restitution of conjugal rights by the Madhya Pradesh High Court. Now, over here, it can be determined that if she was abused by her father-in-law as a result of a relationship with her husband as a consequence of the court's ruling, then the court's decree is responsible for the incident. Now, when we talk about 19(1)(e) and Article 19(1)(g), the decree of restitution of conjugal right violates a spouse's right to reside in any region of India when he or she is forced to live with another spouse in his or her marital residence. Furthermore, in many circumstances, it infringes on one's freedom to practice and profession. Now, the wife in the case of Tirath Kaur versus Kripal Singh was away from her husband to practice a profession. However, due to some disagreement, the husband asked his wife to give up her employment, and when she refused, he submitted an application for the restoration of marriage, that is, restoration of married life. The wife was forced to live with her husband as a result of the court decision. So, restitution of conjugal rights, yes, in some cases has been treated as article violation of Article 19 and Article 19(1)(g) and Article 19(1)(e).